The 5-year rule allows the government to claim your home, and most older adults do not discover this until it is far too late to take any action. If you are 65 or above, if you own your residence, if you have any savings whatsoever, you need to learn precisely how this rule operates because the people who are meant to clarify it for you have a very compelling motive to remain silent. There is one particular document that can halt the entire process before it ever starts, but most estate lawyers will not mention it unless you request it by name. I will share what that document is called before this video concludes. The rule itself is known as the Medicaid 5-year look-back, but the title is deceptive. It is not truly about looking back. It is about penalizing you for actions you took when you had no clue you were doing anything improper. Here is how it operates. If you ever require long-term nursing home care and the average stay in this country now costs over $18,000 per year, you will almost definitely exhaust your funds. Therefore, you will have to request Medicaid to handle the bill. But before Medicaid covers a single dollar, a state caseworker will review every bank statement, every property record, and every gift you have given for the previous 60 months, every individual transfer, every check to a grandchild, every car you signed over, every dollar you shifted. Then they determine a penalty. The penalty is not a fine. It is something harsher. The state takes the total amount you transferred during those 60 months, divides it by what they label the regional penalty divisor, which in most states falls between $10,000 and $12,000, and the result is the number of months you are excluded from Medicaid coverage. During those months, you must cover the nursing home yourself at over $9,000 per month, even though the entire reason you requested Medicaid is that you do not have $9,000 per month. This is the snare. You transferred the money, therefore you cannot pay. But because you transferred the money, the state will not pay either. So, who covers the nursing home? The nursing home does not care. They will sue. And the first asset they will target is your house. Most people believe the rule only catches large transfers. That is incorrect. The look back catches everything. A $400 Christmas check to your granddaughter applies. Paying for your son's wedding applies. Helping a grandchild with college tuition applies. Forgiving a loan to a family member applies. Selling your car to your nephew for $1 applies. Even charitable donations above a certain threshold can apply depending on the state. There is no birthday exception. There is no holiday exception. There is no I did not realize exception. The federal annual gift tax exclusion, which clears throat, currently rests at $19,000 per recipient, has nothing to do with this. That is an IRS provision. Medicaid is a completely different system with its own guidelines, and Medicaid does not care what the IRS permits. A gift that is perfectly lawful under federal tax law can still activate a full Medicaid penalty. Most older adults do not grasp this distinction. Therefore, they believe their gifts are protected. They are not. Now here is where it gets harder, and this is the portion that devastates marriages from beyond the grave. If you are married and your spouse enters a nursing home, you might assume the law shields the healthy spouse who stays home. There is a safeguard. It is called the Community Spouse Resource Allowance, and in 2026, it rests at $157,920. That is the maximum amount of countable assets the at-home spouse is permitted to keep. Everything above that figure must be spent down before Medicaid will cover 1 cent. $157,000 sounds like plenty until you consider what it actually has to address. Property taxes, home repairs, Medicare premiums, food, gas, medications, emergencies for the rest of the healthy spouse's life, which could be 20 years, which works out to roughly $657 per month. That is the math the state anticipates you to survive on while your husband or wife is in a facility that is billing over $9,000 per month for the same time period. But the house, surely the house is protected. The house is the one thing they cannot access. That is what almost every senior in America thinks, and it is incorrect. The house is exempt while you are living and occupying it. Therefore, Medicaid will not compel you to sell it before you qualify. But the moment the Medicaid recipient passes away, a program called the Medicaid Estate Recovery Program initiates. Federal law mandates every state to attempt to recoup the cost of care from the estate of any Medicaid beneficiary who was over 55 at the time benefits were received. The recovery target is the house. The state submits a claim against the estate. The heirs are informed they must either settle the bill in full, often hundreds of thousands of dollars, or sell the home and surrender the proceeds. The average estate recovery claim in this country now surpasses $74,000. In some states, it is over $200,000, and it is not optional. It is not negotiable. The federal government compels the state to pursue the house. Therefore, the house your parents promised would pass to the grandchildren ends up going to the state of wherever they happen to reside in. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older statute on the books called filial responsibility. These laws state that adult children can be held financially accountable for the unpaid nursing home bills of their parents. For decades, these laws remained dormant, but starting in 2012, after a Pennsylvania appeals court determined that a nursing home could collect $93,000 from an adult son for his mother's care, the floodgates opened. Therefore, the snare is not just that the state claims your house. The snare is that the nursing home, after the state completes its recovery, can turn around and sue your children for whatever remains. I will provide you a real example. A widow in Ohio, age 78, transferred $45,000 to her daughter across a 4-year period. Birthday gifts, holiday checks, some assistance with a car repair, nothing she considered uncommon. She entered a nursing home in month 47 of those 4 years. The state divided her $45,000 by the Ohio penalty divisor of $7,463 per month and excluded her from Medicaid for 6 months. The nursing home charged her $9,200 per month for those 6 months. Total bill, $55,200. She did not have it. The home placed a lien against her house. She passed away 8 months later. The state then submitted an estate recovery claim for an additional $140,000 in care costs. Her daughter received a letter notifying her that the home she grew up in was being sold by court order. There is a strategy that some lawyers use to lessen the impact when there is no time left. They label it the half a loaf. The concept is that if you or your spouse already requires care, you transfer half of your remaining assets and use the other half to cover care during the penalty period that the gift creates. It preserves something. It is better than forfeiting everything, but it requires exact timing. It requires a specialized lawyer, and it has to be completed before the Medicaid application is submitted, not after. Once you apply, the strategy is void. The seniors who lose everything are almost never the ones who prepare. They're the ones who were never informed planning was an option. They sat in a hospital room, signed a power of attorney, and started writing checks to the nursing home with no idea that with one phone call to the right kind of lawyer 2 years earlier, they could have shielded the house, the savings, and the inheritance. Now, I informed you at the start that there is one document most estate lawyers will not mention unless you request it. Here is what it is called. It is called a Medicaid Asset Protection Trust. In 5 particular states, including Florida, Texas, Michigan, West Virginia, and Vermont, there is also something called a ladybird deed, which achieves part of the same objective for the home. Specifically, a Medicaid Asset Protection Trust is an irrevocable trust. You transfer your house, your savings, and your investments into the trust. You no longer technically possess them. The trust does, but you can still reside in the house. You can still collect the income from the investments. You just cannot withdraw the assets back out after the trust has been in place for 5 years. Those assets are no longer evaluated by Medicaid. The lookback cannot access them. The estate recovery program cannot access them. The house is secured. The savings are secured. Everything inside the trust passes directly to your heirs without going through probate, without going through estate recovery, and without being claimed by the state. The reason most lawyers do not reference this is straightforward. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to establish correctly. A standard will cost $200. The senior walks in requesting a will. The lawyer drafts them a will, and the discussion about long-term care never occurs. Therefore, you must walk in already knowing the correct phrase. You must say the words Medicaid Asset Protection Trust out loud. And you must inquire whether you qualify, and you must do it at least 60 months before any care is required because the 5-year clock does not begin until the trust is funded. Here is what to do this week. First, pull every bank statement from the last 60 months and search for any transfer over $500 to a family member. Make a list. You need to understand your exposure before you speak to anyone. Second, find a lawyer who is certified in elder law specifically. The certification is called CELA, which stands for Certified Elder Law Attorney. A general estate lawyer is not sufficient. You need someone whose entire practice is centered around Medicaid planning. Third, ask that lawyer by name about a Medicaid Asset Protection Trust. And if you reside in Florida, Texas, Michigan, West Virginia, or Vermont, also inquire about a ladybird deed for the home. Fourth, get the trust funded immediately because every day you delay is a day added to the back end of your 5-year clock. Fifth, Tell every adult child in your family to review this exact same information because the rule does not just impact you. It impacts everything you plan to leave behind. The 5-year clock begins the day the trust is funded, not the day you choose to plan, not the day you contact the lawyer, the day the assets actually transfer. Therefore, the most costly day in your life is the day after you should have started.